Is this right? What is the May? June, April, July.
Oh, where is it? Where is it? Where is it?
Let's see what I have sent here.
Okay, got it.
There we go. Agenda approval. Is it? Yeah, it's that number 4.
Okay.
We have this. We do. So,
What's the date on that? 6/23.
let's see. That should be add. Okay, so we have
It's
this.
James. Hey, James. Hey, Nancy.
Good evening.
After 2. PC after 4. Wait a minute, close the session on PC after 4. PC after 4. Okay. Guess we're just waiting on Bill.
Did you hear from Ms. Gilmore, Bellamy?
I did not.
Okay. Are we waiting for Ms. Hudson also?
Yeah, I was about to. Mr. Wheeler, did you get an email from Ms. Hudson by chance?
I'm seeing. Can you hear me?
Yes,
Yeah.
sir.
I can see. I'm seeing that now. I'm sending her a link.
Okay.
Hi, Bill.
Hey, how are you, Jeff?
Good, thanks.
Mr. Wheeler, what does the little label down the bottom that says live transcript is available mean?
So we've turned on live transcription for our Zoom webinars. And if you click that link and you click view full transcript, you can see the transcript getting built as the meeting goes on. Sometimes helpful for those doing minutes. If you save text, save that text before the meeting ends, you can grab it.
Okay, I think I may have missed it here.
But you can also hide the subtitles if you don't like seeing them on your screen. It's entirely up to the viewer.
Okay, so looks like we do have Ms. Hudson and everybody that.
Hi, Cynthia.
What was I about to do?
Right.
Good evening, everyone.
Evening. Looks
Good
like
evening.
we do have everyone here. I was about to do something, but I forgot what it was.
Is
Anywho,
Deidre coming?
I did not hear back from Ms. Gilmore, and I don't believe Ms. Robinson got a reply either. So I believe this is going to be it. And oh, there we go. That's what I needed. And looks like most everyone is here. And with that, I would like to call this meeting.
Oh, there she is.
Oh, hold on. Let me go there. Oh, cool. Hi, Ms. Gilmore. Can you hear us? Ms. Gilmore?
You
Well,
might be
she's-
on mute.
Okay,
Maybe on mute.
I mean, that's fine. I mean, as long as, ideally she can hear us. Where'd he go? Okay. Oh, here we go. Hi, Miss Gilmore. All right, we'll just move forward.
Her audio is not activated at the moment. Just her camera is available.
Is that something that she needs to do? Or
Correct.
okay, very well. All right, so to call this meeting to order, given that everyone's here, we'd like to do the agenda approval. However, given our understanding that our topic 3 may not be necessary, would like to add public comment after, well, I suggest that we add public comment after the agenda approval, public comment after the hearing procedures discussion, and public comment after number 5, the ordinance discussion. I can't submit a motion, but it would have to come from one of you, but that's my suggestion if anyone else has any changes.
I would move for that.
Is there a second?
A second.
Okay. Ms. Robinson, would you pull the board?
Yes. Mr. Brown,
Yes.
Ms. Carpenter,
Yes.
Mr. Frazier,
Yes.
Ms. Gilmore.
She's muted.
Yeah, I'll come back.
Okay.
And Mr. Mendez
Yes.
and Mr. Watson.
Yes.
Okay.
And we'll just, that passes, so I'll be fine. And so we're on to item number 3, which is supposed to be a closed session discussion. However, through conversations, it looks like that won't be necessary. Does anybody want to comment on that or at all? Okay.
Mr. Chair,
Yes, Ms. Hudson.
I'm just going to raise as a preliminary matter following discussion with the city attorney that to the extent there's any question about whether or not, given that the purpose of your special called meeting was to take up the subject matter that would have been the closed session discussion, that it is still appropriate if that discussion, that subject matter is addressed in this meeting in open session. And I'm saying this basically to address any concerns that there may be about the fact that special meetings must be limited to the subject matter for which they were called, as opposed to anything else. So not doing the discussion in closed session, if that's what, as that happens to be the case, given the change in the agenda, doesn't negate the proper basis for the special meeting. I just wanted to make sure that was clear on the record.
Very well understood. Does anyone else have any comments or questions? Okay, so seeing there are none, we will move on to, oh, wait a minute. sorry, I skipped the initial public comment. So Mr. Wheeler, would you see if there is any public comment available?
Thank you, Mr. Chairman. We have 9 people in the audience. If you'd like to address the board, please click the raise hand icon in the Zoom webinar. Each person will get up to 3 minutes. We have 1 hand raised at the moment. It's Sarah Burke. And Ms. Burke, I'm going to keep track of time on my phone, but you've got 3 minutes. Please go ahead.
Great. Hey, everybody. I was just calling to, or speaking to say a couple of things. One, I don't see a copy of the updated ordinance in your agenda packet. And so it's going to be very hard for the public to give comment or follow the ordinance discussion and possible vote without having ever seen a copy of what you all have drafted. So I'm not sure if that's an oversight, but I would discourage a vote on your drafted ordinance if you don't have any meaningful public input, because you haven't made that public input possible. And in the same regard, I'm wondering what you all do to try to get word out about these meetings. So I think I learned about this meeting a couple hours ago. And it's the city website, as you all know, and is hard to navigate. And I'm wondering what is done to be sure that you all are getting enough public input on the work that you're doing, because it really is so important and so valuable to hear from the public. So thanks a lot.
If there's anyone else who would like to address the board, please click the raise hand icon. If you're on via telephone, you can press *9. I don't see any other hands, Mr. Chairman.
Okay. Very well, thank you, Mr. Wheeler. Let's see here. Okay, now we are now we are at hearing procedure discussion.
If I might interrupt,
Yes,
Mr. Chair, I think we can address some of Ms. Burke's concerns.
sure.
At least one of them. Sarah, there was, I think we came to understand after our regular meeting last week. We sort of started out thinking that we would be in shape to vote on a resolution which incorporated the ordinance tonight. I think in the days since then, we have come to the conclusion that that's not going to be advisable to do. And in fact, what I think is going to come out of this meeting is we're going to discuss the ordinance among ourselves and then post it for public comment prior to actually taking a vote. And again, there's always a balance between how fast you want to do things and how how much input you want to get from the public. And I think that in this case, we definitely want to get more input from the public, and so you will be seeing the ordinance shortly.
And I'd just like to add that, we'll be covering the hearing procedures as well. So it'll be hearing procedures and ordinance. And Ms. Hudson, you're on mute.
Hearing procedures have indeed been posted. Is that correct, Mr. Chair?
Well, these ones, the updated ones, we're going to keep in the same spirit of the actual of the draft ordinance, so they'll be posted at the same time. We won't vote on those at all until after we have this discussion. So,
I guess I just wanted to piggyback on Mr. Mendez's comments and the speakers about the fact that the kind of last minute switch to an open session discussion of the ordinance draft meant that the ordinance draft was not posted along with the agenda so that the public had it. It was being treated as an exempt document. And I didn't know if the board wanted to perhaps take up a discussion whether or not it perhaps is appropriate that the public have, if you're going to be discussing in open session, a copy of the ordinance, either as you're speaking to it tonight, or I think that is something that the board might want to consider discussing, whether or not discussion proceeds on an ordinance that the public in a public open meeting has not seen.
Sure. Does anyone want to comment on that or have discussion on that?
Is it technologically feasible to post it as we speak?
Yeah, I believe that. I don't know, Mr. Wheeler, if I got that to you here.
You could, excuse me, Mr. Chair, if you send it to me, I can post it.
Okay, very well.
Are we, the question I think is about public comment, and it's nice that we share this document tonight, but how will that allow for the public to, look that over as we're discussing it and, come to some type of public comment they might want to make?
There will be an opportunity for that before the final vote next meeting, Nancy.
Next meeting.
Correct.
We're not going to vote on it tonight, in other words.
Okay.
Is that right, Mr. Chair and Mr.
Yes,
Vice Chair? Yeah.
Yes, that's correct, Mr. Fraser.
Okay. Very good.
So
Very good.
Let me.
And we can go through, some of the provisions of the document. I mean, we won't have time to go through, chapter and verse, but sort of the important aspects of what's in there we can discuss. Cynthia, do we need did I hear you say we needed a formal vote to decide to relax the FOIA exemption?
No, I did not say that. No.
Okay, just wanted to touch the base there. So, okay, I guess the board has agreed that we're going to put this up and then put this up tonight as we discuss it, and then put it on our website.
What you did was amend by a vote your agenda this evening, which removed the motion to go into closed session to discuss legal advice regarding the choices made and perhaps a draft amended ordinance. Now that is an open session discussion, my concern is that ordinarily, for instance, if this meeting had been noticed and the agenda provided at the time that it was noticed to discuss the ordinance and to discuss it in open session, we would have provided that draft ordinance at the same time that the agenda was posted almost a week ago now. It does concern me a bit if you're just to discuss this in great detail tonight in open session, which obviously with an opportunity for public comment afterward, that as the speaker has indicated, there is not the opportunity for the public to see that. The only manner in which I certainly understand that because of the logistics of deciding at the last minute not to favorably vote to go into closed session, you didn't have the opportunity to have posted this, a week ago when you first decided to do this, but it may be technologically possible. I guess Ms. Robinson can let us know if you could perhaps, if you wish to talk about it tonight in detail in open session, that you share screen perhaps, and people who are watching the meeting can certainly be able to see it. But I do think it requires some serious discussion as to whether or not you should take up the ordinance tonight at all, as opposed to just the hearing procedures, which have been posted a number of times. But again, that's up to you.
Does anyone have does anyone have discussion on that or any comments?
Well, as always, yes. So I mean, it does seem like a path of least resistance here would be to post the draft ordinance and reserve discussion until our next regular meeting, which is August 12th. The schedule keeps slipping. And I guess, so I'm conflicted about that, I guess.
I mean, I think that there is, I mean, I've given Ms. Robinson both, and they can, is Mr. Wheeler, is there an opportunity to share to do a share screen for a Word document?
You bet. It's activated, and you should have the green button at the bottom.
And that would be on mine. Okay, there it is. Okay, so Ms. Robinson, have they been posted?
I'm just seconds away, so.
Okay, right. So let's move this out of the way. Okay, so so we'll cover those two, and then also we'll have this public comment period between now and the next next meeting, and we can have additional public comment at that point before we actually do the vote.
And again, I think that we can limit our discussion of the ordinance tonight to the high points.
Okay, very well. Ms. Hudson, does that suffice?
I think it's appropriate to do that and as long as you're not actually taking a vote tonight without having had the opportunity to post that ordinance so that the public is aware of what you were acting on, that should work. A no action discussion and sharing the screen. It is a lengthy document, and sharing the screen, as you talk about it, probably doesn't give the public the time that they need. But to the extent you're going to post it afterward and not act, I think you're acting appropriately.
Okay, very well. What is this amended? Okay, and let me find this file. I don't know how to sound basic. That's not the screen that we want.
So, excuse me, if I just may confirm, we are posting both documents, correct?
Mr. Mendez, the ordinance is going forward, is that correct?
Yeah. Mm-hmm.
Okay. Yes.
At this time, is your agenda item the ordinance or the
No, it's the hearing procedures.
Start with the hearing procedures, yeah.
Okay, so those should go back to my screen. Come on. I'll try this again. There we go.
And then one last question. Oh, I'm sorry, go ahead.
No, you can go ahead.
I don't want to disrupt your meeting too much. No, please go ahead.
Okay, sure. This is the draft of the hearing procedures. It's already been sent out to each of you. I don't know if anyone has had any questions or comments on it. I've looked at it several times over, obviously in conjunction with our legal counsel, to also take into consideration comments from the People's Coalition. I believe Ms. Burke. I believe also Mr. Fogel. And yeah, so those have been incorporated into the document itself. Does anybody have any questions or comments from what they've read so far?
I have one, what may be a minor question, and that is, throughout the document, we talk about the CRB holding hearings, but I do not see that who presides at the hearings as being specified anywhere. Is that understood to be the chair?
Is there, let's see, I believe on the last, let's see, we can, I believe there was another document that the chair would preside. It doesn't seem to be included, so we can include that on updated changes, specified who would preside.
Chair?
Yes, Ms. Hudson.
To the extent that the hearing procedures, at least as they're presently drafted, contemplate that the hearing would be held as a meeting of the board,
Oh, yeah.
then the usual rules with respect to who presides at a board meeting would apply, and that would be the chair, and in the chair's absence, the vice chair.
That's satisfactory to me. That's fine.
Okay, very well. Are there any additional concerns or questions? And just for the public's sake, this is about 6 pages, so we'll kind of walk through this a little bit. First section, obviously, being hearings and meetings. From time to time, the PCRB may hold meetings based on Robert's rules or any PCRB adopted procedures that those would control. This is authorized under Chapter 2, Article 16 of the City Code. We may receive information relating to complaints from any person or entity that's submitted in writing, and the person making the submission identifies their name, address, and phone number. For the purposes of these procedures, a complaint is outlined as from a civilian regarding conduct of law enforcement or civilian employees of a law enforcement agency. Information relating to complaints shall mean incidents including use of force by a law enforcement officer, death or serious injury to any person held in custody, serious abuse of authority or misconduct, in addition to or civilian employees, law enforcement agencies serving under the authority of the city. Again, information related to an investigation conducted internally by law enforcement serving under the city's authority. Does anyone have any questions on that particular section? Okay, very well. Going to page 2. Upon receiving the complaint, the PCRB shall determine whether any applicable ordinance of the city permits the PCRB to conduct a hearing. The PCRB shall conduct hearings in accordance, with the procedures set forth here in this particular document. The parties to a hearing shall include any person who alleges they were the subject of police officer or employee misconduct set forth in the complaint, the Charlottesville Chief of Police or the designated representative, the Chief of Police, and police officers and employees who are the subject of the complaint. Section 2, regarding advisors. Throughout the hearing process, all parties may consult with and be represented by counsel or other individual advisor or representative. Section B, the role of the advisor or representative. I know that there was concern previously that unless you were an attorney, you could not speak on behalf of a particular individual. Here, the parties may be accompanied by their respective advisors at any meeting or proceeding related to the hearing, which shall not include the right to be present during investigative interviews or be privy to the investigative efforts of the PCRB related to the complaint. So, layman's term, the advisor can be in any meeting except those that include the right to be during investigative interviews or investigative efforts of the PCRB. While advisors may provide that support and advice at any meeting or proceeding, unless the advisor is also an attorney, the nature of his or her participation in the proceedings on behalf of the party shall be determined by the board. And I believe that that's the section that really covers that, the question of whether or not someone who's not an attorney would be able to assist. No advisor or representative may in any manner disrupt such meetings and or proceedings. Regarding the investigation, we did want to cover this section in AI. upon receipt of the complaint, the PCRB shall compile a cause to be written or cause to be compiled, a written record related to the complaint. The record shall include material from the CPD, which we shall request by notifying the chief of police of the complaint. Within here, we have, question 10 days. I think that may be sufficient, but does anyone have any objection or questions surrounding that? And if Ms. Hudson, if you look like you want to elaborate on that. Okay. Does anyone have any?
I don't mind if you'd like me to.
That's all right.
I would just be wondering if Ms. Hudson has a thought about that from having been in similar meetings or drafted similar ordinances.
I have seen 10 days in other procedures, certainly in consultation with Mr. Brown and with Mr. Mendez, who throughout the course of their involvement with the board have reviewed a number of ordinances and procedures. 10 was in the original draft that we thought about, and we included it here, but highlighted it with a question mark in case this was something that the board had some particular interest in discussing as whether or not 10 days or fewer or more is more appropriate. There is no magic to that time period. I think it's just a matter of how quickly you think it's reasonable for the police department to respond.
Does anyone else have any questions? Okay, so we'll skip that.
Oh, hey,
I do have a quick one, Bellamy, real quickly. With the 10 days, and Ms. Hudson can answer this because she has the knowledge that I don't, but does that incorporate just 10 calendar days, regardless of whether weekends are in there or some type of holiday or holiday situation? I just didn't know if that should be spelled out or whether 10 days is just language that everybody understands. It's 10 calendar days.
Typically, unless a statute or a rule or an ordinance specifies working days, a failure to do that means it's calendar days, which is another matter that the board can take up. If you wanted to modify that to be 10 working days rather than calendar days, up to you. Or any other number of days.
No, thank you. I just point of clarification for me to understand that.
Understood.
Mr. Watson, did you have a?
Yeah. So one of the things I was wondering, I didn't see in the draft hearing procedures. I know we're not talking about the ordinance, but I think the draft ordinance kind of touches times when you would have a closed hearing as opposed to a hearing that's open to the public. And then there's a little bit of language in there about information being confidential or sensitive that would push the decision to have a meeting or a hearing being confidential. I didn't see anything, and I could have missed it, but in the draft hearing procedures that would make a determination of whether a hearing would be completely public or whether part or all of it would be a closed hearing. Yep.
Let's see.
But there is a little bit. I know we're not talking ordinance tonight, but I think there's a little blip in there again about that in the ordinance, the drafted ordinance.
I don't see. Ms. Hudson, are you able to speak to that idea that Mr. Watson does bring up a good point regarding the possibility of going into closed session? I guess I missed that.
Well, to the extent that, again, we're talking about a meeting, these hearings being conducted as a meeting of the board. So your usual, regular, legally available discretion,
right,
which would be exercised based on exemptions in the Freedom of Information Act, exist for you to determine on a case-by-case basis whether the matters at hand in a particular hearing would suggest the hearing be closed.
Okay, very well.
So there's no blanket requirement they all be closed, no.
Mr. Watson, does that answer your question?
Yeah, that answers that question. And I have just one more. I was just go ahead.
Mr. Watson,
Yes,
I'm
ma'am.
sorry. And if you want to actually see how we have addressed that in the procedure draft, it's at section, I'm sorry, I'll just flip here because I'm looking at it in hard copy. It's section 4, policies governing hearings. Item G, Virginia Freedom of Information Act, where the last sentence says the PCRB shall exercise any discretion available to it under applicable FOIA provisions in the interest of transparency as dictated by the balance of public and private interest specific to any particular complaint as to whether a hearing is going to be open or closed. So it's just preserving that discretion.
So who makes that determination? Does the board have to vote on that? You know, who, you know, if I was, okay, the board has to vote on it. Okay.
Again,
but if you're,
I'm sorry.
Yeah, go ahead.
I'm sorry. Go ahead. I was going to say, just as you would have to vote on a proper motion for a closed session under any circumstances, the board would have to do that under these circumstances as well.
Okay. All right. Thank you.
Am I? And it looks okay. So we're still at 10 days. Are there any additional questions?
Yeah, going back to the 10-day period after a complaint has been filed.
Yes.
And that's that 10, just to make sure I'm tracking correctly, that's the 10 days where, wait a minute, we would want to get the internal affairs information. My question is, you know, let's say 5 years goes by and we have a complete changeover in the police department and even on the board to some degree. And, you know, is there any teeth or any mechanism that sort of enforces the CPD to follow along with, if I'm looking at the 10 days right, you know, what, you know, is there anything that kind of makes them sort of play by the rules? Or any other mechanism? Yeah.
Well, I think the shall in there is really what instructs. It's like there is no, the shall makes it mandatory that that it has to happen.
And I also think that in 5 years, James, we would hope to have a much stronger ordinance, and much stronger operating procedures, which will clarify, you know, the obligations for information sharing.
Okay. But what if they flat out said no?
Well, you can't. I mean, the procedures are pretty. If this, you know, goes all the way through, I mean, that shall. I know it's whatever, you know, legalese, but it's that has the enforcement that they have to do that. That's a compelling verbiage that they have to do.
Yeah, I think the police chief might. I think the police chief might say, A, it's impossible to do it in 10 days. B, there's information and there's confidential information in here that we don't want to share with the public, and so you guys can get lost. But I think the only recourse we have under the current ordinance is then to go to the city manager.
Right.
So.
All right. Yeah, I was just wondering.
Well, I think there's also where is as representatives, there should be rules, confidentiality, determination, pre-conference hearing, recording. Material city upon receipt of the complaint should cause written record shall include the complaint history advisor, the internal affairs. Ms. Hudson, is there a provision where the board has to sign a confidentiality agreement for the information from the police department?
I seem to recall.
Trying to unmute myself.
Go ahead, Ms. Hudson.
I was going to say, you might be thinking about a reference to some language in one of the versions of the draft amendments to the ordinance, as opposed to the hearing procedures. And it related more to, I believe, the investigator on behalf of the PCRB signing the confidentiality agreement. That's not a part of these procedures relating to hearings.
Well, I was thinking of that because with regard to Mr. Watson's, you know, what if they, I mean, are like, well, we're just not going to give it to you. I think that this idea,
the 2019 ordinance requires us to sign confidentiality agreements before receiving IA files. I can give you a section on it.
Well, no. I mean, so yeah, I mean, if that's gonna be the overarching for this, then yeah, I guess we would be covered under that. Okay. All right. Are there any other questions or comments? Okay. All right. Moving along. So, Chief of Police shall cause to be delivered. Complete copy of internal investigations file. Complete complaint history, including any final disciplinary action taken, any material or evidence utilized or collected by the police department during its internal affairs investigation related to the complaint. Any additional written information provided by a party to the PCRB that the party believes to be relevant to the complaint. The investigative material from the CPD, information shall be provided. There it is. The investigative material and from the CPD and information provided by a party to the PCRB shall be presumptively confidential and may not be disclosed. There we go. That's what I was looking for. By the PCRB, except, yeah, there we go. Upon certification by a vote of the PCRB, that it's germane to a hearing and serves a public interest to be disclosed. Okay. Moving along to the FOIA section, upon receipt of a FOIA request for investigative records, CPD or for personnel information, the PCRB shall further request to the city's FOIA officer and the chief of police shall have a duty to respond to that request and the right to determine whether or not any discretionary exemption will be asserted with applicable law. Does anyone have any comments or questions prior to going to section 4? Okay, seeing none. Section 4, policies governing the hearings, presumption of lawful conduct. All parties are presumed until findings are made to the contrary to have acted lawfully in accordance with applicable policies and procedures. That the presumption may be overcome only by a PCRB finding that there is sufficient evidence by a preponderance of the evidence that any person or entity acted unlawfully or in violation of applicable policies and procedures. Participation by the parties and witnesses in the absence of a lawfully issued subpoena. No party or witness is required to participate in the hearing, but the PCRB may infer from the parties or witnesses' voluntary absence from a hearing despite notice and requests to appear that their truthful participation would have been averse to the interest of that voluntary participation. Prior or subsequent conduct of a party may be considered in determining a pattern, knowledge, intent, motive, or absence of mistake. The determination of relevance of such conduct will be based on the assessment of whether the previous or subsequent conduct is substantially similar to the conduct under investigation or indicates a pattern of unlawful conduct or conduct that violates applicable policies or procedures. Under relevance, PCRB may determine in any hearing the relevance of any proffered evidence to to include or exclude certain types of evidence from the hearing. Virginia's rule of evidence, Virginia's rule of evidence contained in Part 2 of the Rules of the Supreme Court of Virginia and the Code of Virginia and applicable case and opinions are not binding in hearings, but may be the basis for arguments in support of the admission or exclusion of evidence, which the PCRB may consider in determining in its discretion whether to admit. The PCR under expert consultation, the PCRB may consult disinterested medical, forensic, technological, or other experts as defined by applicable law when expertise on a topic is needed to achieve a fuller understanding of the issues presented by the complaint. The activities of the PCRB is subject to Virginia FOIA, both as to access and to the requirements for open and public meetings. Does anyone have any questions or comments before going to section 5?
I had a quick question, Mr. Chair, about that item G from Ms. Hudson. What's the standard in terms of someone FOIAing, our proceedings, our records, if it's been a closed meeting? I mean, are they protected? I'm just concerned about the subject of the complaint, the individual against whom the complaint has been made, and what is the level of protection for them in terms of privacy?
It will depend on the nature of the basis on which confidentiality is sought. If we're applying the usual rules of the Freedom of Information Act in terms of what records you may withhold from mandatory disclosure, you'll have to look for an applicable exemption to make sure that it applies. For instance, if it involved alleged criminal conduct or as they call it, delinquency conduct by a minor, for instance, it is against the law to share confidential information about that kind of conduct by a minor, and you could withhold that from a freedom of information, from disclosure under the Freedom of Information Act. To the extent we're talking about confidential personnel information,
yes,
very often that, and that's going to be much of what you're talking about in many of these hearings. Whether you withhold that or not is discretionary, and that's where it's really going to be a judgment call for the board as to balancing the public interest in transparency against the interest to be served by withholding the personnel information of any given individual involved in a hearing, in particular whose conduct is the subject of a hearing. But it's going to largely be dictated by the existing exemptions under the Freedom of Information Act.
Could you envision a scenario in which the subject of the complaint, say, has retained legal counsel and they're pushing hard to protect that information? I mean, I mean, are we going to, where does that lead us? Does it lead us into court to settle that sort of dispute? I mean, I can imagining an attorney representing the subject of the complaint wanting to push back hard on that issue.
Well, once again, if we're talking about information that is the subject of that is personnel information regarding any Charlottesville city employee or public employee, the provisions of the Freedom of Information Act apply to give the discretion to the city. Okay. And the board is a component of the city as to whether or not to disclose that. Now, certainly the individual employee through his attorney or her attorney directly may challenge that and pursue whatever kinds of proceedings or avenues for relief that they think are available. And obviously the city would have to respond accordingly depending on what the venue is for that challenge.
Okay, great. That's fine. Thank you. Okay. Thank you, Mr. Chair.
Mr. Chair, let me just note that I've just noted that the version of the draft hearing procedures that you are sharing at this time are not indeed the the latest draft. You'll recall that at section G, I indicated that language had been added at the very end that essentially summarize what we've just been talking about, and that is that the board is going to have to exercise its discretion on a case-by-case basis as to whether meetings are open and closed. That is in the latest draft that I shared with you and the vice chair. And if you'd like me, if that's not something that's immediately available to you, I can certainly send it to you now. As you go ahead. There have not been, there were no material changes so far in what you've reviewed, so you could still pick up from this point, I believe. Would you like me to do that?
Well,
let's see. Let's see here.
You'll note that that draft is, there's a date at the bottom and it indicates June.
Yeah.
I think. And
did the most updated
one sent you one last week?
Okay, let's see. With that out of the way.
I have the June 10th version.
Go on. That's. Yeah, Ms. Hudson, do you have that immediately available?
You can go ahead and give with the overview of the major sections, and I will find that and send it to you.
Okay.
In electronic form. I'm looking at it in a paper copy.
Okay. All right. So yeah, we'll come back to that, to the G section. Are there any additional questions or comments?
Yeah, I have a question. Trying to find my little spot here on my computer. Okay, with the section F where it talks about expert consultation. So if we have a hearing and we need to bring in an expert witness, which is really only something I've seen on television, do we have to pay for that? Does that person get subpoenaed? You know, if you need I don't know, if there's something, I don't know. I mean, there's different types of experts, right? Various things that happen with cases. How do we compel that person to then show up and testify? How does that work?
Well, go ahead. Well, in my experience, yeah, there's typically a fee associated when you're looking at experts. But Dr. Frazier, you can.
Yeah, I mean, having been one countless times, you know, you're contracted either verbally or in writing with an agreement to show up, and it's expensive.
Yeah.
So I don't know what the budgetary implications of that are, but it, you know, expert witnesses don't come cheap.
Yeah, and I also want to point out something that we talked about in the work group a lot, which is how frequently this kind of expertise is required, and the answer is once in a blue moon. And I think this, I may be wrong, but I think this provision here is included as a precaution, just in case.
Mr. Mendez, I could envision, I'm sorry, Bill.
Yeah, go ahead.
I can envision a scenario, though, where at their own expense, the subject of the complaint might want to get evaluated or bring in an expert. And, you know, I think it's my understanding there's no prohibition there, but it's going to be on their dime.
Yeah.
Well, what about, it seems like there could be scenarios where we would want to bring one in too. You know, like in the George Floyd case, there might have been 20 expert witnesses, right? So, but yet we're not, arguably not at the level of a traditional
criminal
court, you know. Yeah. So, you know, do we have to dig into our budget? Will the city dig into their budget? Who's going to pay for those? I mean, and that may be another subject, but it's something I would hate to need one and then, oh, we don't have any money to bring this expert in, you know. So that's just something to think about.
And I guess the question there is, Mr. Chair, or Mr. Vice Chair, do we have discretionary funds in the money that council has allocated that would could be used toward that eventuality?
I think the answer is that we would need to submit a budget which included a contingency if we thought that was necessary. But I want to emphasize again the rarity of this happening, at least in terms of the kind of complaints and appeals that we've seen from the Charlottesville police for the last year and a half. So yeah, the answer is if we want to do this and we want to take it seriously, we would need to put a line item in our budget request that said X thousand dollars expert witnesses.
I mean, this is a good discussion because, budgets will be starting to be reviewed, I guess, in about 6 to 8 weeks for next year. I mean, they start the budget process September. So maybe our new executive director can take that up.
Yeah, and I would, to Bill's point, strongly encourage us to put a line item in there. I mean, we don't use it, but I'd sure rather have it if we don't, if we need it.
Yeah, and that's what I was thinking is you don't want to get to that point and then it's like, who's going to pay for this?
James will write a check.
Yeah. Oh yeah.
And we also need to remember that expert witnesses tend to occur in testify much more frequently in criminal proceedings than in administrative proceedings.
Correct.
And we aren't doing criminal proceedings. We're getting out of the way of criminal proceedings. So that's another reason why, okay, we can put something in our budget, but again, I'm not sure it's going to be a huge issue.
Yeah. Agree.
Are there any other additional comments or questions? Okay. Going to section 5, conduct of the hearings. Prior to the hearing, PCRB shall receive written record. The purpose is an opportunity for the parties to address PCRB about issues relevant to the complaint. The order of the hearing is that the PCRB board shall hear any motions or requests at the commencement of the hearing and rule on them or defer ruling upon them as the board deems appropriate. Each party may make an opening statement at the commencement. PCRB, the board and the parties may call witnesses or seek to introduce documentary evidence not already part of the written record. The board shall determine the order in which parties shall present evidence. The parties may submit written questions to the board to pose to witnesses, whether in the nature of cross-examination or direct examination, and the PCRB members may pose questions to any witnesses. The PCRB shall determine whether any question is inappropriate for submission to a witness. Ms. Hudson?
Yes.
I believe that there was a question on this particular one. Would you happen to recall by chance in the updated draft?
Yes, the updated draft language following the sentence you just read would be the PCRB may permit examination, including cross-examination of witnesses by party representatives who are attorneys licensed by the Virginia State Bar. The PCRB shall determine whether any question is inappropriate for submission to a witness or rule on the propriety of questions allowed to be posed directly to witnesses.
Okay.
And we were in the process of addressing broadening that language in response to some public inquiries.
Okay. Were you able to locate the?
I am still looking for
Okay.
the version that I sent to you, and I think I've located it here. I don't want to interrupt the meeting.
Sure. Well, I mean, they're only
delay the meeting.
Well, there are only a few
Yeah.
that are out there. Mr. Mendez.
Yeah, sorry. This is just an issue here, but I can see that there be a substantial dampening effect if people knew that they were going to go into court and the opposing counsel was going to ask them whether they had a drinking problem or whether they were sober on the night in question or whether they had any felony convictions and even the prospect of that would be I think would be dampening on the the people's willingness to come forth and make statements. So I would urge that we work on this and place a little bit more distance between witnesses and counsel. And I kind of feel a lot happier with the previous language that allows the board to make the final decisions and be a buffer between, professional counsel and witnesses, than to allow the professional counsel to get up there and put on a show, basically.
Chairman Brown, if I could speak as well. I agree with what Mr. Mendez has said about the chilling effect that this kind of procedure could have on folks being willing to even be a witness or to even bring their complaint forward, because they've already been, traumatized to some degree, to the point that they're feeling, that they are filing the initial complaint. It also, this section of all the sections, is the one that I have a lot of problems with, because it sounds so formalized, and, terms that we associate, of course, with court proceedings, which can also have deleterious effects on residents or citizens and wanting to come forward and engage with this board as an oversight board to, what they perceive as police misconduct, and what, eventually comes into a hearing. So is there a way to make this a little less complex or a little less intimidating sounding? And that's just my comment. So I'm just throwing it out there. But that's where I'm seeing my thoughts on this particular section only.
Sure. 1 second. Let me do this here. Do this here. Delete that. Come on. And then let's go over here. Comments. Delete. There we go there. Okay. It still says June 1. Where is, let me go down to G4. That's still there. No, that's still the same.
Chair, if you're looking for particular provisions, would it help if I just shared the parts of the document that I understand to be the latest, that are the ones that come into question if they've been revised?
Well, I was looking
easier than you switching documents completely. I'm sorry.
Sure. Well, I was looking at the clean version, and it appears to be similar to what the one is that we have right now.
Okay, and we're at conduct of hearings, part C4.
Yeah, that's
this examination.
Yeah, they looked. And they're dated. They're dated the same.
I don't know. I'm thinking that we've gotten some drafts crossed out. The latest language I'm seeing is the Pcrb may, as I mentioned, the Pcrb may permit examination, including examination of witnesses by party representatives who are attorneys licensed by the state bar. But I know that we changed that language in the last draft, and apparently you're not seeing it in the one you're looking at.
Correct. And the clean one, yeah, the clean one is also similar to this particular one as well. That's what I was trying to.
You didn't see the edit that was made, is that right?
Correct.
Yeah, and I'm not seeing it in the document I have either. I'm just hoping it's not a matter of it not having gotten saved.
Okay.
But we can certainly hold that question, and we can send to the board the language that you and I exchanged that would expand on that point.
Okay.
Okay.
So we are going back to conduct of hearings. Okay, that was the witness section, and then and at the conclusion, section 5, at the conclusion of the presentation of evidence, the parties may make closing arguments to the board. The board shall provide written notice to the parties no less than 14 days. The date, time, and location of the hearing. The hearing may be continued by the board from time to time until completed. Regarding location of the hearing, a hearing may be conducted with all parties physically present in the same geographic location or at the discretion of the board. Any witnesses or other participants may appear at the hearing virtually with technology enabling participants simultaneously to see and hear each other. Members of the board must be physically present on the same location except as may otherwise be authorized by FOIA or other provisions of state law. And does anyone have any questions or comments on page 5 before we wrap up page 6? Okay, pre-hearing conference. The Pcrb may convene a pre-hearing conference during which preliminary matters related to the hearing are discussed and are resolved. The parties will be provided advance written notice of the date, time, and location of the pre-hearing conference. The board shall make arrangements to create either an audio or audio-visual recording of the hearing or transcript of the hearing prepared by a court reporter. Determinations by the board after hearing. The board will objectively evaluate all relevant evidence, both from the written record and presented during the hearing, and make a final written finding within the time in the form provided by an enabling ordinance for each allegation of misconduct in the complaint. Whether there is a preponderance of the evidence that misconduct occurred, whether the board concurs with any finding by the Charlottesville Police Department, whether the board finds the Charlottesville Police Department investigation incomplete, unsatisfactory, and if so, in what regard. And then with respect to civilian complaint or police conduct complaint, to the extent permitted by the city ordinance, whether the board wishes to consult with the chief of police and or the supervisors of a police officer or employee whose conduct is subject of the complaint to make disciplinary recommendations applying the police department disciplinary matrix in cases that involve serious breaches of police department policies and professional standards, and other determinations as may be provided by the city ordinance, any of which to be implemented by the city official or employee with ultimate supervising authority over officers and employees of the police department. Informal resolution section. At any time after receiving complaint and before issuance of written findings, the conclusion of the hearing, the board and any party may propose an informal resolution of the complaint, which may be adopted if all parties and the Pcrb agree to such resolution. Does any, Ms. Hudson, with regard to this particular document, is there anything in the new that is substantially different other than those minor pieces in, I guess it's 4G and the section 5 C4 regarding written requests?
No, there are not. There weren't any other changes on pages 5 and 6.
Okay, very well. Does anyone else have any additional questions or comments?
I just have one, just in case, you know, and I may be overthinking this, but if we have a complainant or we have someone in the public who may be following a public hearing, you know, on a complaint, will we have a mechanism in place to provide some type of ADA compliant resource, whether it be someone who is, you know, signing during the actual hearing, or if there are some other formats that we would provide, you know, to make sure that we are inclusive with, you know, our report of findings and things like that for the public.
Well, I would anticipate that we would be utilizing some aspect of City Hall. I don't think the city is going to provide rent for us to go somewhere else. And I believe City Hall itself is ADA compliant to cover that. The other alternative via electronic means would, I guess, speak for itself.
But I was speaking more, as the final report that, that the board will draft up or whatever, with the findings of what's being brought to us, would that be in a format, not necessarily the physical location, which is great, to be able to use City Hall. But when we talk about having folks who can, be a part of our community, if you know what I mean.
Unfortunately, if you could elaborate more.
Well, what I'm saying is there are sight impaired folks who may want, may request through FOIA or whatever, a copy of our proceedings for whatever reason. And, can that be, of course, prepared in a format that's suitable to them? And I will leave it up to the ADA compliance officer. I think they did have or may have on staff to do that. And the same thing if someone just hearing impaired and just, I'm overthinking it, of course, but I also want to make sure that we are cognizant that, not all of our complainants or public community members will, have functionality of all their senses and capacities, and to make sure that we're, aware of that. And as we get our hearing procedures honed in and finalized and sent to council, that we would be aware of that and be cognizant of that.
Sure. Mr. Wheeler, does the city itself have any communication mechanisms for what Ms. Carpenter is speaking of, specifically related to hearing and visually impaired community members?
My general sense for the board's consideration is that, the ADA laws require the city to make accommodations to people that request them. And I know, on your agenda and on the council agenda, we always have information at the bottom that describes how the public can access the ADA coordinator. And so I don't know that you need to get any more specific in your procedures, because I think the city staff have to be aware of that no matter what you include here.
Okay, very well.
Does that help, Ms. Carpenter?
Yes, it does. Thank you.
Are there any additional questions or comments? Okay, seeing none. Mr. Wheeler, would you poll the audience for public comment?
Well, and before we move from this, where do we go from here?
Well,
on the hearing procedures. I mean, we're going to post them again and then vote at their next meeting. It's just.
Sure. I think, well, we're going to get the updated covering those two sections. I believe it's 5G and 4G and 5C4 from Ms. Hudson. We'll get those posted out there, and they will be able to comment or review them during the this 30-day period, comment on them at the next meeting, and then we would be able to vote there. These per Ms. Hudson, those are the only two sections that are really out of play here, and everything else is as is.
Okay.
If there's nothing else of a substantive nature.
Okay.
And I'll also state too, at this time, if I may, Mr. Chair, with your permission, Mr. Mendez had inquired about that 30-day posting requirement.
Oh, yeah.
And what you understood to be a requirement. And I did speak with City Attorney Lisa Robertson, because I was not aware of any general legal requirement for a 30-day posting for further public comment. And she confirmed that perhaps you were thinking of additional public comment posting periods that apply to the city council's actions where they are considering matters that legally require a public hearing, or other public bodies of the city where their proceedings on certain measures legally require a formal public hearing. And that's not the case with respect to these matters before the Civilian Review Board. You may permit as much additional posting and comment time as you like, or it could simply be the comment time that you allow in the meeting.
Yeah, I just, just pointing out here that our next regularly scheduled meeting, it's the 14th today, and our next regularly scheduled meeting is on the 12th of August, and that's, like 1 day or 2 days short of 30. And so, well, I don't think we should necessarily postpone a vote yet again for another month when we will continue to give the public adequate opportunities to comment.
And let me say too that this is also just reminding the board that these are recommended or proposed procedures that you submit to the council. The public would, if you were to vote on them at any point, they will be subject to further comment at that stage of council's consideration.
Are there any?
I'm just thinking that, then we should, post what we think is the most recent draft, which has the 2 sections fixed, and solicit comments, and then plan at our August 12th meeting to adopt them.
Okay. Well, what happens if we have a good comment that might have an idea that we might want to incorporate or change? How do we do that?
I think
you
it's
can incorporate it.
And I think that most of the actors who have participated in this process have commented already, but I think we've incorporated some of their comments into this section. Obviously, the 4G and the 5 section would add a little bit more, but I think that's already been done quite sufficiently. Not to say that it won't change, but I think we're pretty well down the road with regard to that.
I have a question to clarify Ms. Carpenter's point for Mr. Mendez. Bill, I assume we can tweak the document as we work through it on the 12th of August.
Certainly.
Yeah. Okay. Just want to make
Absolutely.
sure. Yeah.
So if somebody comes up with a very good idea, that's fine.
Are there any additional?
That's what the public comment is. Okay.
Yeah.
Are there any additional comments or questions? Okay, seeing none. Mr. Wheeler.
Thank you, Mr. Chairman. We have an audience of 9 people on the webinar right now. If you'd like to address the board for up to 3 minutes, please click the raise hand icon in the Zoom webinar. First up is Sarah Burke. And Sarah, I'll keep track of time on my phone, but you're on with the board. Go ahead. You've got 3 minutes.
Hey, y'all. Sorry, my kids are screaming, so good luck listening to my comment. So I have not had a chance to make any comments on, or I just have not made any comments yet on the hearing procedures. This was a very hard process to follow, I'm not gonna lie. It's hard to review them while you were talking about them, having never seen this draft before. I don't think this is a practice you all should get in the habit of. I think significantly more input before you're making such important decisions is important. I'll try to give comment in 3 minutes based on the section. So under 3A, or maybe little 1, you talk about the CPD compiling a written record, including all of I's files. which includes material or evidence utilized or collected by the CPD. I find the term written record confusing because it's not clear to me that that includes video interviews, body camera footage. And if so, if it is supposed to include all of that evidence, which sounds like it is, then I don't know why you're using the term written record. I'm wondering if you could just say a complete record. About the 10 days that the CPD has to provide materials, I would guess that what you're going to get is a lot of pushback from the CPD about being able to redact materials in time that they think they need to redact. And so it sounds like the process as is that they go to the city the chief of police can go to the city manager and they deal with that. But I think you all should be much more explicit about what the CPD has to, the reasons that the CPD has to provide for why they cannot meet a deadline if they cannot meet a deadline. Because I think it's clear that there is a compelling of that 10-day timeline with the shall language, but it's not clear then what happens if the city manager says, sure, you can have an extension, and whether you all get any say in how long that extension is or for what reasons those extensions should be permitted. I had a concern with 5C4, which is that the complainant has to, as one of the parties, has to submit all questions in writing. This, I don't understand who could actually do that. And I'm not sure when that time frame is that those questions are supposed to be submitted in writing and how far ahead of time. That's a real red flag for me, that the complainant doesn't have a strong voice in this process and that they're not able to react on the fly. And thinking about the, so just in general, I think, oh, sorry, Brian, I was looking at all these notes I took. I didn't see that. I just think that if I saw this, if I read this as a complainant, I would think I needed a lawyer to go through this process, and I wouldn't file a complaint under these particular hearing procedures. I wouldn't see them as ones that were looking to address the officer's conduct. I would think of them as sort of a witch hunt toward my own, or ways to hinder my own allegation. So thanks a lot for listening. Sorry, I went over.
Our next speaker is Teresa Hepler. Teresa, you're on with the board and you've got 3 minutes.
Hey, it's Teresa Hepler from the Legal Aid Justice Center. I'm going to try to keep my comments to 3 minutes. I have a lot to talk about. So the first piece was 4A, presumption of lawful conduct. And I think the all parties are presumed language is problematic simply because your mandate is to review police conduct, not to review the party's conduct, just the police officer's conduct. So I think it would be a lot more fruitful if it said all subjects of complaints are presumed, and that the presumption may be overcome only by a Pcrb finding that there's sufficient evidence, that any subject of a complaint acted unlawfully or in violation of applicable policies or procedures. I think you really need to limit that language as much as possible to the police officer who you are supposed to be reviewing. The next comment I have is 4B, participation by the parties and witnesses. This read pretty scary to me, that you are giving yourselves the ability to infer from a party or witness's absence, despite notice and request to appear, that their truthful participation would have been averse to the interest. So that just reads to me that you can make an inference that a witness who you wanted to, or the complainant who you wanted to appear, is lying, which is a very terrifying concept to me, because the whole reason why you have the review board is because people might be afraid to come forward. They might be afraid to testify. They might fear retaliation by the police officer. You don't need to make that inference. If they don't appear, then the evidence is what it is. But that's very frightening to me. Another piece was the notice of hearing, and I'm trying to find that was under 5D. The hearing may be continued by the PCRB from time to time until completed. I think you guys would do yourself a service by limiting yourselves as to the reason, the basis that the hearing may be continued. Right now, it's too vague, and that doesn't seem fair to the complainant. And then just in general, I would just lift up with what Ms. Burke had said, that this process is very complicated, especially for someone who is a complainant who might not have a lawyer. You certainly don't want to make it so that you can't go through this process without having a lawyer, because you can bet that the police officer is going to have their lawyer there, and then you're going to have this imbalance. Thank you, Brian. So then you're going to have this imbalance where the police officer who you're supposed to be reviewing has a lawyer and has all the advantage, and the complainant doesn't. Thank you.
If there's anyone else who would like to address the board, please click the raise hand icon. Next up is Jeff Fogel. Jeff, you're on with the board. You've got 3 minutes.
To the board my concerns about the hearing procedures, but I want to just focus on the question of whether or not the lawyer representative or the complainant, him or herself, has the opportunity to ask the questions of the people who are testifying against them. Now, I don't know what, if any, experience any have in administrative proceedings, in comparing those administrative proceedings to when, actually what I wanted to say was, you should go find an administrative body that does not allow cross-examination and take a look at how that works. And then take a look at nearly all administrative bodies, which do allow for some cross-questioning. Obviously, you as the panel are entitled to control the lawyer. If the lawyer is getting abusive or out of control, that's totally within your control. But you can't have a real hearing, cannot discover the truth if the complainant or the complainant's representative is not allowed to ask any questions whatsoever. And I really urge you to see what that would look like and look at actual administrative proceedings that do that, because you won't find very many. And so what you're proposing when you say that you can't ask any questions, only we can. And again, this is very difficult because we're not going to know what the testimony is of anybody before we get to the hearing. So to ask us to figure out during the course of the hearing, as we're listening to people, to also propose to you written questions that you might ask or might not ask is an incredible burden and does not lead to the truth. So I encourage you to adopt that section which allows the panel to control the lawyer, but does allow for at least some cross-examination. Thank you.
Thank you. If there's anyone else that would like to address the board, please click the raise hand icon now. I don't see any additional hands.
Okay, very well, thank you, Mr. Wheeler. Where's my, here, is this it? Looks like it's it. No, it is not.
Ms. Hudson, while Mr. Chairman is looking up, anything in the comments tonight that we should look further into from your perspective?
At the board's election and in your discretion, we can look at everything. I will say that with respect to the matter of allowing cross-examination or direct examination by representatives of the parties, that the latest draft was expanded to at least attempt to better address that that issue. Maybe the manner in which cross-examination is permitted by the hearing procedures might be re-examined at the board's request, but certainly these procedures expressly permit now cross-examination or direct examination by parties as well as by the Pcrb.
Okay.
Okay. Are there any other questions? Go ahead.
Yeah, Chairman, I really think these comments kind of speak to what I'm concerned about when it comes to hearing procedures and creating not a hard boundary, but a boundary that people who are already, been victims of a system, denying themselves due to fear or intimidation or lack of understanding or the ability to do different things that I think the speakers talked about. I think that particular section may need to be reworked. I'm not sure that I would vote for it next month. As it is now, without some serious, hopefully some consideration in the working group about these things that were discussed about, the manner that the hearing is conducted, the cross-examination, although there is, a new version that kind of addresses that, which we'll get. And the pushback, that's a good question about pushback from the police department. If they have to redact anything, what is our, what will be the process for us to, not for us, but for the oversight board to address that. So I think some very good comments, and I think some very good questions that should be considered before we even vote on this in August or September.
I know that Mr. Mendez, Mr. GSD, I think that we can, get this wrapped up by August. I don't know that it's necessarily prudent to extend it further down. But your comments are taken under advisement.
Yeah, one of the comments I just wanted to make is again, we're hopeful that this procedure applies to one hearing, and that after this one hearing, we have a stronger ordinance and stronger bylaws. We will have the ability to do our own investigations, and so we will have a lot more direct access to information down the road. And it's just an illustration of how weak we are under the current, under the current ordinance and in the current bylaws. I don't think that should stop us from moving forward. And I thank Sarah and Teresa for raising excellent points, and Jeff for raising excellent points. And I think we can incorporate those and discuss them and perhaps vote for them at our next meeting.
Hey, very well. Are there any additional comments or questions? Seeing none, we come here. We are going to move to, that's the ordinance discussion and vote, but prior to, I didn't intend for the hearing procedures to go that long. We are at 8 o'clock. Perhaps there, I don't know what anyone's time is like, but perhaps there could be a motion to extend 30 minutes until 9 p.m. But that's just a suggestion.
I apologize. I'm going to have to jump off here pretty soon.
Okay.
Yeah.
Very well then.
And I can, as I said, touch the high points relatively quickly and then give people 28 or 29 days to digest, what we've put together. And so hopefully we won't take too much longer.
Okay, sure, Mr. Vice Chair Mendez, the floor is yours. Do you need me to put,
okay,
yes.
now,
do you need me to share the screen, or are you going to share
may
screen?
Yeah, okay. Is it possible for me to share my screen?
If you go to the bottom, it should be that.
I have a, yeah, oh, okay. No, that's not the one I wanted. How do I get back to another screen here? Okay.
There should be, if you hover down, there should be
new screen. Yeah, new screen. God dang gummit. Okay, here we go. Okay. These are the high points of what is in the new ordinance, and I certainly want to thank Cynthia for helping set this up and greatly refine the draft. Rather than go through section by section, what I will do is hit the high points, and after the meeting tonight, I will put section numbers next to all of the major authorities that we have are asking for, and then we can post that. And so that will leave the public with almost a whole month to review where we are. Also, again, we have in as late as recently as May shared a previous draft, and a lot of what is in, if you go through this current version, it's fairly similar. Anyway, what we have, the authorities that we are requesting in the current draft, importantly include receiving all citizen complaints. And again, this is, the idea is to change the current opt-out situation in which the police reserve the right not to share complaints if the box is not checked. I believe this is very important for us. Even if we don't investigate all the complaints, we need to see all the complaints in order to do an ongoing oversight job efficiently. The current version allows the board to identify complaints for independent investigations and to conduct those investigations. Like many things in the ordinance, the specific criteria for which complaints we investigate are left to the operating procedures. And so there's still much work to be done to define when and under what circumstances we would request an independent investigation. Also, in keeping with the 2020 statute, we also have the right to independently investigate incidents without complaints that constitute a serious abuse of authority. And the language in our draft ordinance is precisely the same verbatim as that in VA 601, 91601. We also have, as previously, the right to review investigations of citizen complaints. There are two expansions here, which we have discussed a lot, and we've discussed with stakeholders and with the city council. And the first being that ultimately we will have the power to review all complaints, even those that are sustained. And we will ask for the authority to evaluate disciplinary actions that were taken as the result of sustained complaints. This is a new thing. We expect pushback on that, but I think it's pretty important. We are asking to hold hearings and exercise subpoena power in order to enforce our, in order to do our job. After making the good faith efforts, we can then subpoena witnesses on production of documents. And then we can also make findings of fact. Once we do an investigation, we can make findings of fact regarding allegations of misconduct. So we can say sustained, exonerated, and so on, or no basis. But that's again for the subset of complaints that we've investigated, which has not been defined. We also are asking for the authority to make disciplinary recommendations on sustained allegations which are serious, as under the vague definitions given in the Virginia statute, and which mostly we're going to have to develop for ourselves. There's a strong language, which I believe came directly from the Alexandria ordinance. Thank you, Nancy. That we also have the authority to receive full access to police department reports, files, records related to complaints and incidents. And this is just a clear statement that the police are expected to cooperate with us and provide information as necessary. The mechanisms of information transfer, redaction are not established to be dealt with in our operating procedures. Much more work to be done. And then finally, we have the right to review internal affairs investigations and other city and citizen police interactions and make policy recommendations. This is pretty much the same as before, except that we now have, I think, a deeper access to the actual internal affairs investigations rather than just to summaries of the same. Those are the big things. There are other sections which relate to less controversial and more housekeeping issues like board membership, training, community outreach, and potentially, who knows, we might want to commend officers for doing a good job, and we might want to develop procedures for allowing mediation in certain subsets of less serious complaints. I think that's all I would want to say now. I'll go and I'll stop and answer questions. I will put up the text of the document in case anyone wants to look at anything in particular, or in case you have any questions that I can answer in reference. So thank you.
Mr. Vice Chair, I did have I did have a couple of questions under section 2.455 on page 6. In the bottom there, starting at line 180 to 184, it appears that there is no real recourse if the executive director isn't doing his or her job or is unduly influenced. Do we have any, or should I say Ms. Hudson, are there any opportunities to remedy that?
If you don't, oh, I'm sorry. Is that to Bill or to me?
Well, I mean, go ahead, Mr. Mendez and Ms. Hudson.
Well, I was going to say that we can, if we are dissatisfied with the executive director, we can ask for a conference with the city manager to discuss whatever concerns that we have. And then we can, if 2/3 of us think that he or she is doing a terrible job, recommend termination. But we have to remember that the executive director is an employee of the city manager. And so we don't, under this document, no, we do not have the authority, strong authority to, beyond that, to register complaints. And that's pretty strong.
Well, I think it's essentially, I think it appears essentially, and Ms. Hudson, if you wanted to comment afterwards, I think it appears essentially says basically, oh, well, this is what we got going on, but you can basically have a door slammed in your face and you don't, doesn't matter, what's said. So I don't know, Ms. Hudson, if there's anything that you've come across for remedying a situation like that.
short of there being some other language in the ordinance the council adopts that gives the board the direct ability to require the termination of the executive director, I don't know what else would be done.
Well, I don't think it's really a deal of whether it's termination. I'm just talking about compelling action that benefits the work of the board itself. If we're saying, hey, he or she isn't doing their job, and there's a different version that says, well, we think differently, it's basically we're out of luck from
Yeah, we also basically I think we also have input to their annual performance review, and I think if the city manager buys this is a whole lot of authority, quite frankly. And one of the things that we talked about at our last meeting or before that was how do we in the context of an oversight organization where the executive director is an employee of the city manager, reports to the city manager, how do you assure adequate independence?
Yeah, that's what I was.
Right, in Alexandria, where they have a different, as I understand it, city code, they set up an independent police auditor who reports to the council and not to the city manager. But even there, I'm not sure how much power the actual board would have in terms of reining in the independent auditor if they get really annoyed. So
sure,
I have not seen the Alexandria ordinance is not set up in the same way that the current ordinance is in here in Charlottesville, where the executive director of the board is hired by and is an employee of the city manager. Some other ordinances, not all, the approach of creating within their enabling authority an entity that is its own separate legal entity from the jurisdiction, much in the same way that localities are empowered, say, for example, to set up an economic development authority or a housing authority. While the locality is empowered by the enabling law to set up those entities, once they are set up, they have an independence legally from the city, and their employees are their own. That is not the case in the construct of this board in Charlottesville. So to do anything in this ordinance that gives you any greater authority over the performance of the executive director of the board would require probably an entirely different construct than that.
Very well. And Mr. Mendez, the second question is section 2-457, line, I guess, 214 to 217. 215 specifically, it says, and the police department shall forward to the board all complaints. And I recall one of our discussions. Well, one is who specifically are we talking about? Is it chair, et cetera? And I recall a discussion with the chief of police where there was an objection to the entire board. So is that thought taken under consideration?
I think it is. There's some issue, a couple of issues with this passage. One, I think that, I think there's an understanding that she would be most comfortable forwarding the complaints to the executive director. And I don't see that is necessarily a particular problem because, suitably redacted they could be shared with the entire board. The other problem here is that it says pursuant that it's going to send us all complaints received pursuant to its receipt procedures referenced in subsection 1. And if the receipt procedures say, oh, by the way, we're not going to send complaints that aren't opted in, then that leaves it open for us not to receive complaints again. And that's one of my comments from Ms. Hudson, is that we need to make it very clear that this should be all complaints and not, not sort of dependent on the police department to decide which complaints we actually get. So, and as I understand it, I think you can go real deep into this and into Virginia law. 91600 requires a police department to have certain procedures in place, and that can be used, in my opinion, as sort of a pretext for reluctance to forward complaints. And so it's an unresolved issue. We need to work on it.
Very well. I think that those are the only 2 questions that I had. Does anyone else have any questions for Mr. Mendez?
Chair Brown?
Yes, Ms. Hudson.
Back to your very first question about the executive director and the level of involvement that the board may have with respect to his or her tenure. I just wanted to reference again the Alexandria ordinance, which I had an opportunity to pull. The head of that independent community policing review board, as they call it, is appointed directly by the city council and serves at the pleasure of the city council. So again, a different construct. I just wanted to let you know that for comparative purposes, since it had come up.
Very well. And in that section, it covered termination and everything, but realistically, my overall concern was the independence aspect, and how do we get the greatest independence from that for the benefit of the board itself, and what our work is to do in the community. So
agreed. Understood.
Are there any additional questions or comments? Okay.
So if there aren't any, so as I said, what I'll do is take the high points, cross-reference those to the specific sections, and we can then post that along with this draft for public comment.
Okay. Is there anything else from anyone? Seeing no, Mr. Wheeler, would you open it up for our last public comment section?
Thank you, Mr. Chairman. We still have 9 people in the audience. If you'd like to address the board for up to 3 minutes, please click the raise hand icon in the Zoom webinar. First up is Sarah Burke. Sarah, you're on with the board and you've got 3 minutes.
Hey, y'all. Thanks for that overview, Bill. That was really helpful to see it so sort of plainly in front of us. It was hard to follow the edits, but I thought those were great comments. Also, Bellamy. I just wanted to know if you guys could be really specific about when you expect the draft to be posted for the public. Is that going to be posted as like agenda material items that are attached to the agenda for the next meeting, for the August 12th meeting, or is that going to be posted ahead of time? And if so, can you help explain for everybody listening how to go about doing that? Most of the materials that I see are posted as materials attached to your agendas. So I'm wondering where you will post the most current ordinance, the date that you plan to post that ordinance, and then what is the plan for the next meeting, August 12th? Are you going to be getting into a substantive discussion sort of line by line like you did with the hearing procedures today? And does that give you all enough time to take in public comment about the ordinance if you also plan to vote on it in that same day? Because at this point, we can't give any real meaningful public comment on the ordinance. I just want to be sure all those pieces are addressed and the timeline is really clear for both for everybody on the board and the public. But thanks a lot for your efforts.
If there's anyone else who'd like to address the board, please click the raise hand icon. I don't see any additional hands, Mr. Chairman.
Very well.
Yeah, it's
Go ahead, Mr. Mendez.
just addressing Sarah's response to concerns. I think that I could have the little crosswalk annotation done by tomorrow morning, and I could send it to Ms. Robinson at that point, along with the ordinance. And I then believe that we can simply post it on the Charlottesville Police Civilian Review Board website. That
would be sorry.
Go ahead.
And that would be tagged under the reports section. And Mr. Wheeler, with regard to the website itself, I don't think the public fully knows that. Do you have the URL for the new website?
Yep, and I'll just share it briefly. I believe we made it charlottesville.gov/Pcrb. Make sure that works. That does.
Okay.
And there are a couple sections in here. We've added some quick links at the top. And then there is a working documents section where you previously have posted draft hearing procedures and some other information.
Okay.
So anything that you want updated, we will post it there. And
let's put it in working documents.
And then Ms. Burke earlier in the meeting was asking about being notified, and this meeting was scheduled shortly after you decided to have it and put on the agendas page, but also we put out a weekly email listing all the public meetings, and that this meeting was in Friday's notice on that. So those people can sign up for on the website under How Do I, and they can go to email notifications, and public meeting notices is one of the options you can sign up for. So I just wanted to share that.
Very well, thank you.
Cool. That's good. Yeah.
That being done, are there any additional comments or questions?
Of course. No, I'm going to be away next week, and before I leave, I hope to have a long overdue draft of our annual report for review by the board. There's nothing in here that should be privileged or a surprise, and so I will send that around.
Very well. Is there anything else? Seeing nothing, is there a motion to adjourn?
So moved.
Second, Mr. Watson.
I'll second.
Okay.
Yes.
Ms. Robinson, would you poll the board?
Yes. Mr. Brown,
Yes.
Ms. Carpenter,
Yes.
Dr. Frazier,
Yes.
Ms. Gilmore,
Yes.
Mr. Mendez,
Yes.
and Mr. Watson.
Yes.
Very well. And with that,
You can eat and then
very well. With that, thank you all for your hard work and tonight.
Thanks,
and,
everyone. Thanks,
have a good night.
Cynthia.
For coming.
Good night.
Bye.
Good night.
Bye.